Peace, 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 peace. Welcome to another episode with the original OG, aka Uncle from Omega FM Radio.co.uk, where we give you a little bit of this and a little bit of that, trying to be the voice of reasoning. Please share, subscribe, and leave your comment. Your comments are well appreciated. Mr. Trevor Dixon.
Omega, Omega, Omega FM.
All right, thank you. Now, remember what I said in the past? I've never asked you to agree with me. What I've asked you to overstand or understand. If we can do that, then we can have a conversation. We can reason. If you don't agree and you don't understand, it don't make a lick of sense. It's going to be frivolous, right? Right. Now, before I go on any further, I have put up two videos, right? And those two videos was about a book called The Prodigal of the Jewish Elders, right? Well, YouTube took it down. I said I violated community guidelines. But if you want to see this entirely, uh, you can go to TikTok, right? That's TikTok at omegafmradio.co.uk. I'll leave it up for a while. Now, this is David Lammy. David Lammy, in the past few weeks, has put a proposal that he would like to do away with the jury system. But what it is that there's a backlog in the judicial system in the Crown Court. So what he is proposing is for the magistrates to take that burden, right? Now that meaning that normally in a magistrate you'll have a judge, you'll have three individuals, what they call judges, but they don't know nothing about the law. Somebody has to tell them about the law, and that's the court of the clerk. He's the one that usually gives them the information, right? Now, they want them to do a jury trial. Now, normally, you go to a magistrate's court, you can get a year and less. Anything over that, you can go to Crown Court. But now they want you to go to magistrate court where you can get 3 years. See what I'm saying? And it's very hard for you to beat your case. So as I said, this is David Lammy, right? And I don't agree with him one bit because under the jurisprudence, this is an old-time law, something where the Crown Court, they deal with what they call a harsh punishment, but the preponderance of evidence, as far as they're concerned, has to be more or higher, because this is why you have 12 jurors, so that they can't be not supposed to be able to be manipulated, but be able to make a concise and cogent analytical decision on their own. So that's the thing about jury trials. You go into a magistrate and you believe that the evidence that you have is strong, right? And you want a jury, you're not going to get the 12. You're going to get those three or a judge. And at the end of the day, this affects people in our community, African, Caribbean, Caucasian, and everybody. All right. Now, as I said, I don't really understand the way this law is done because in the UK, they have a thing called joint enterprise. This is joint enterprise. Joint enterprise, read what it says. Right? In legal terms, guilty by association refers to the notion of a person can be considered guilty of a crime merely because they associate with someone who has committed that crime. Right? So what that's telling you, right? What that's telling you, I know you by somebody else and somebody commit a crime. If they look at my phone and see that I've spoken to that individual, boom, I can get caught up in joint enterprise. It was a big thing going on in the UK. And that's the difference between the UK and the United States. There's a disparity within the law. Because in the United States, it's based off of the Constitution. In the UK, it's not. All right? So, all right. Also, you can hit us up on Instagram. All right? I'll put it up there. You see this on Instagram. All right. So, this is joint enterprise. Now, in the UK, right? In the UK, they don't have in the penitentiary or what they call county jails a law library. In the United States, every county jail, state jails have a law library where you can actually go in there and fight your case. All right. Over here, as I said, what the books that they have available, excuse me, the book that they got available is called the Archibald book, right? And as I said, it's called the Archibald book commentary. And usually the court of the clerk, that's the person that has the information to tell the judge or tell the magistrate. So it's a precarious position we're going to be put in, or anybody that goes in the judicial system. Right? Now, I'm only speaking from a paralegal perspective because I was on Rikers Island. I was a law clerk. I have my paralegal certificate in research. Right? I was there for 2 years. Right? Now, pardon me, sir. Over here now, right? You don't have law libraries in the penitentiary. What you got is a general library. And the only book that you can get from them is called the Archibald book. It's a red book, right? And it has nothing to do actually in actuality with law, right? Nothing to do with law, right? And you're lucky if you can get that because if an inmate has that in their cell for like 2 weeks, 3 weeks, it's only one book that's supposed to circulate around the whole prison. All right. So now the only time that that book can be available to another inmate is unless it's a shakedown, and they're going to check the cell down and see if he's got too much or her's got too many books. All right. So that's the bad thing about it. Now here's the thing, right? UK has a thing called the Magna Carta. The Magna Carta is based off of what is supposed to be the purpose of it. Let me rephrase. The purpose of that is to stop what they call the aristocrats, the so-called firm, the so-called royals, right, from abusing the barons. Those what they call the bourgeoisies. The bourgeoisies was supposed for them not to abuse the proletarians. The proletarians, they are the average working people, right? And that's it. Right? In the United States, as you or you may not know, it's based on the Constitution, right? Now, with the Constitution, let's say you over here, you know what they say is caution. Anything you said shall and will be used against you in a court of law, right? That's the same thing in the United States. Anything you say shall and will be used in a court of law against you, right? Now, over here, if you believe that your rights is violated, now this is where I need your help. I really and truly need your help so that I can help you to help yourself, to maybe help your children that can help themselves because this becomes very convoluted. And to me, it don't make a lick of sense. So I need your help. I'm asking you all to leave your comments, all right, and suggestions on how we can address this problem. Where can we go for this information? All right. So now in the UK, you have a caution. You believe your rights was violated. You decide to say, well, all right, you want to challenge it. Where do you get the book that sets precedent? You have to have a law case that's saying this is it. This is what sets precedent. Correct? You don't get that. Now, in the United States, right, they have a thing called Miranda. I want you to take a look at this, right? Miranda. This is if you believe your rights have been violated. This case here in the United States, under the Constitution, allows you to challenge your conviction, right? Under Miranda, meaning anything you said shall and will be used against you in court of law. So if they did not do the right thing, this is the case here. Here's the fact. The Supreme Court decision in Miranda versus Arizona addresses four different cases involving custodial interrogation. In each of these cases, the defendant was questioned by police officers, detective or a prosecuting attorney in a room in which he was cut off from the outside world. In none of these cases was the defendant given a full and effective warning of his rights. At the outset of the interrogation process, in all the cases, the question elicited oral admission, and in three of them, signed statements that were admitted at trial. So if you believe your rights is violated, This is what it break down the case for you now. Even if you are an inmate on Rikers Island or upstate, you can go into the law library, do the research, and say, "But wait a minute. First of all, I'm going to put in ineffective counsel because my counsel should have came across this case here or this information." See where it breaks it down into many different subsections, all right, where you can actually shepherdize the case. You can shepherdize just mean to see what was the latest case, all right. So that's what you can do in the United States. In the UK, where would I find this information? That's the question. Somebody now believes their rights was violated. Where do you get the case that sets precedent? Under identification in the United States, it's called Wade. Wade versus the United States. That's identification, meaning over here, if they put you in a lineup and they put you with, say, like five short Caucasian males, right? And you're the only black male there, or African male there, let me put it that way, all right? Or African Caribbean. And you saying, "Oh, there is something wrong." They're not supposed to, because they're supposed to look something like me. My height, my build, my complexion, something similar. All right. You see law and order in the United States, so you're supposed to know how that go anyway. So that's underway. So now in the UK, where would I go? Where would I go to say I don't like the way my identification lineup was done? I want to challenge it. How do you challenge it? Now you've got to go into the courtroom and you've got to have a barrister. That's another story right there of its own, right? Now, this is Wade, all right? So you can see where you can go, what information you need to fight your case. It directs you to other books, like 388, United States Constitution book, page 220 volume, I guess. All right. So you can see where they break it down and give you the opportunity to fight your case, right? Not in the UK. So what is it I'm saying? Trying to say the best way possible is that I think you need at least 100,000 signatures to go to legislator to amend this law, right? To put something in that people can actually challenge their case, right? If they think that something was done or their lawyer is not representing them in the right way, right? Take for example, right? You get arrested, right? Robbery in New York is defined under Article 160 of the New York State Penal Law and categorized in 3 degrees, each carrying a different felony classification and potential sentence. Right now, you get arrested. You go to Brooklyn House, Queens House, whatever it is, Rikers Island. Somebody comes in. I'm a law clerk, and they say, "I've been arrested. All right, for what?" um, for robbery. All right, I don't need to know nothing about your case. That's your case. You keep it to yourself. All right. But here's the book. Go to the shelf, take off the penal law. This is what he will see, or he will see. Right. Then I will go and say, okay, you have a good overstanding. That means that you took somebody's property without permission, and that's it. All right. Now, here's another book called the CPL, Criminal Procedure Law. It's a book about this thing, right? And you have subsections, and it has at least 20, I'm lying, about 100 cases. It starts off in small print, maybe like three, three sentencing, three sentence to basically give a description of your case. And when you go open up the book, now they've got it on Nexus Lexus, so you don't have to go through all of that, right? But at least you can fight your case, all right? Now, the judicial system in the UK is so twisted that you don't know if you're coming or going. So, as I said before, I need your help because let's look at it from as a jailhouse lawyer's perspective. Jailhouse lawyer. This is a jailhouse lawyer. All right, Amir Abu Jamal. Let me show you Amir Abu Jamal. Here he goes. He's a jailhouse lawyer. He's been in prison for the longest, but he stays in the law library. The funny thing is, He had gotten a lot of people released from prison, but he can't release himself. There's another individual in that was in Clinton Correctional Facility, Jerry the Jew. Same thing. He was the one that helped with the Attica riots, right? But he was the same one. He was they called him a jailhouse lawyer. He was able to get nearly everybody home, but guess what? He couldn't get himself home. All right. So this is what I'm trying to explain to you, that you're going to need to have some kind of something that legislation puts in place so that you can actually fight your case. So if you have 100,000, then you may put in a petition, whether you black, white, come together the best way possible to see how you can address this problem. Because really and truly, all of this is going to affect African Caribbean people more than anybody else, especially our children. And if we knew anything about the law, had some kind of idea or structure of the law, then we could say, oh, challenge this, challenge that. All right? But apparently we don't have that. Now, this is Jeremy Corbyn. Now, with this, as I said, this is not to saying that Palestinian action is right or wrong. That's not what I'm getting into. I am just getting into it from the perspective of law, right? What they can do, what they can't do, what they should do. Are they acting in an arbitrary and capricious manner in its totality, meaning that they're above the law? Long story short, all right? Now, the law is supposed to protect you and I, but the law is not supposed to be abused. As I said, I'm not taking no sides because I'm not trying to go through that thing there where they take me down and said I'm anti-Semitic and the whole 9 yards. All right. This is Jeremy Corbyn. Take a listen.
Hunger strike action in order to draw attention to the fact that they are remand prisoners. They're not guilty of anything. They haven't been convicted of anything. They're remand prisoners. Yet the trial date is now set for January 2027. That is 14 months on from now. For people who have a case they want to answer, they want their day in court, obviously, and they'll get that. But why are they in prison at all? They could quite easily be released on remand, and that is one of the requests they've been making. I would like to think they're going to get a fair trial. But there's something quite odd and interesting about this. A number of prisoners taking hunger strike action in this prison gets hardly any coverage on the mainstream media in this country. Now, what has happened to the principle of fearless investigative reporting by the British media? Why can't they report this case? Why can't they make a comment about the unusual nature of being held all this time on remand with apparently little prospect that will be released ahead of the trial date, which, as I said, is 14 months away? What's happened to our media? If a prisoner is on remand, then normally they're treated very differently to a convicted prisoner. They've been convicted of nothing.
Okay, as I said, it's not about commenting on the case because of the UK, which is different from the United States. You cannot make, under a pending case, you cannot say nothing. Nothing. In the United States, you can see with the Pete Diddy case, the R. Kelly, the O.J. Simpson, while the case is going on, you have commentary, you have legal experts able to break down the case for you, tell you which law is this and what law is that, what constitution is being violated, and so forth. In the UK, it's just a total shutdown. You don't get nowhere with it. Now, as I said, the whole purpose of this is that if they're saying that they've moved their case up to January of 2027, right? Is there a law saying yes, they can do this? Is there a law? How can I do my legal research if I wanted to do the research myself? How am I able to do it? I can't do it. And that's the problem with the judicial system in the UK. Right? I want you to take a listen to this. As I said, I'm not taking no sides. It's just some of the commentary, the things that was said under the law. Take a listen.
Do you know there are 8 people currently on hunger strike for Palestine in UK prisons? Yesterday, I visited HMP Bronzefield to see Gesser Zuhra, a 20-year-old who's now on day 38 of her hunger strike. Her health has seriously deteriorated, yet she shows extraordinary courage and determination. Gesser and 7 others are part of the largest coordinated hunger strike since Irish prisoners in 1981. 5 of them have already been hospitalised and there's been hardly any mainstream media coverage. Many have been held on remand beyond the 6-month legal limit, so they must be granted immediate bail. Their other demands include the right to a fair trial and full respect of their rights whilst in detention, especially access to medical care. And they are also calling for the deprescription of Palestine action. This is unfolding while a Labour government abolishes jury trials, a cornerstone of our legal system, and handpicks judges to oversee judicial review cases like that of Palestine actions.
You heard?
Our civil liberties are eroded and our right to protest is being undermined. So this is a pivotal moment. Please.
All right, I'm stopping it right there. The judicial system. Now, these cases, some of them seem to be serious, will be turned over to magistrates. As I explained to you about magistrates, right? As I explained to you about magistrates, they don't know Jack, all right? I'm not asking you, I'm telling you. Now, the reason why I got to say this, all right? I got to give you a background. Yes, it's a story I've told before, but listen to it. Okay, I was charged under the section law of Malicious Communication Act of 2013. All right. What happened was I was on Omega Radio, on a non-commercial radio station. I had put up a Kwanzaa for 3 years. All right. It was free entry, free food, everything. Bless the man that had that place down by Unity Center. He gave it to us for 3 years straight. He passed away. I can't remember his name. It's so long, my bad. All right. But for Saturday and Sunday, right, 1 day out of the year, which called it was the spirit of Kwanzaa, all right, for 2 days, for 3 years straight. My money was accumulated. Now, during that period of time, people was allocated to do certain things. Now, part of the allocation was for a Rastafarian female. I'm not going to call her name, but that's prison, and a member of the Nation of Islam, which I will say is Leon Muhammad's right-hand man. Right now, at the end of the day, was where was this £1,500 was not shown. So I gave a countdown, 30 days before I start calling names, and I call names. Next minute, you know, I was arrested. Malicious communication. All right. I said I want to have a jury. I want a trial. My trial was a magistrate's trial. 3 judges. Right. Now these 3 judges don't know nothing because the clerk has to keep coming up and explaining them the law. Now I know from out of the United States, for the non-commercial radio station, I was guilty. That was no issue. So I was going to roll with the blows. But it came to about the community's money because it wasn't my money. So I said, I'm going to fight it. I go into the courtroom. They have a screen put up in front saying that I'm a menace to society. All right, so I'm intimidating so-called witness. The 2 witnesses, the male and the female, they come on the stand. Nation of Islam and Rastafarians came on the stand. And my lawyer questioned them. My lawyer said to them, show them 3 paperwork, a bank account, their signatures on a document, and an advertisement, a promotional with my organization on there, was presented to both of them. They don't know nothing. They don't know nothing about them. 3 judges, one is a black one. All right. Now, my lawyer asked one of them, the male, because he said, I threatened him. They said, well, what's a threat? Well, he said, I'm grimy. That's not a threat. What was the threat? Oh, he said I was a thief. That's not a threat. The black judge turns around and says, he already answered the question, move on. My lawyer says, no, he has not answered the question. Yes, he has moved on. All right. Now I go to Pentonville. I end up doing 6 weeks there. I end up getting a fine for £2,500. I said, I'm going to appeal it. This is how I was able to understand how the judicial system works. Because when I went into Pentonville, the first thing, knowing that I was a law library clerk on Rikers Island, first thing is, I want to see the law and understand this law. I go in, I'm going to the library, thinking it's a law library. It's a general library. You have books like Tom Clancy, Sidney Sheldon, Steven Spielberg, and all them kind of things, Stephen King, I mean. You have all them fictional books, one or two non-fictional. So I'm looking. Archibald book is there, right? But it's in somebody's set. It took me 3 weeks. It never had nothing to do with me, right? So now I come out. I'm appealing it. I go to Crown Court, right? I go and speak to because I wanted a jury trial. I go and speak to one of those barristers. They wear the wigs, the white wigs. She says to me, "You will not be able to win the case. Why not?" Because the threshold for you is low. So I said, hold up, what do you mean by that? The threshold for you is low. So I said to her, all right, cool. Under the 2013 Malicious Communication Act, which was put in by legislators, it states if you are to cause somebody unduly duress or hurtful feeling, emotional feelings, right, and you know the information to be false, not true, right, then you're guilty. So I said to her, I said, well, wait a minute, hold up, wait a minute. But the information I've got in front of you is saying, here's the paperwork. She's saying, yes, you're correct, but the threshold for you is low. So I said, what do you mean by that? She said, the threshold for you is low. I said, well, wait a minute, hold up. The preponderance of evidence on the criminal proceeding, meaning that if you, it's loss of freedom and liberty. That's why the preponderance of evidence has to be high. In a civil proceedings like Judge Judy, the preponderance of evidence can be low. Right? She said, yes, everything you're saying is correct, but you cannot win because the level for you is so low you cannot win. Not only that, all that person has to do is come in and cry and say, oh, boo, boo, hoo, 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 you're guilty. Well, wait, hold up, what do you mean by that now? Well, the reason why is because the judge is going to believe that person because they're saying they're the victim because they're the one that pressed the charges. So I said, but shouldn't they, like in the United States, something like that, a judge is going to want to say, well, okay, if you're going through extreme emotional duress, I need to see medical evidence that you was going to the doctor, you're taking Prozac or whatever it is, right? She said, yes, you're correct, but not in the UK. So this is where it becomes a problem. I had to drop everything, all right? Now, this malicious communication, right? Do you remember this lady? And I'm trying to not make it too long. Damn. Do you remember this lady? She's called, what's her name? What did I, can I just, what's her name? Her name is, sorry. Her name is Denise. Do you remember this lady here? Now, I have no love in my heart for this woman, right? I don't know her from a hole in the wall. She's a black woman. As far as I'm concerned, she is maybe a white woman, a Ku Klux Klan woman stuck in a woman's body, black woman's body, all right? The thing with this now is that there was an injustice done to this woman, right? And this injustice was that I'm looking for the part so that you can see, right? The reason why while I'm looking, the reason why I'm not too fussy over it, because she might have been one of those females that seen an inmate getting beat up. And she might be the one to turn and say, would you like some coffee? Would you like some tea? Do you need a rest? All right. I thought I had it here. Just give me a hot minute. Well, what it was, right? I'll take it up at the top of the cranium till I can find it. Denise, right, sister, boyfriend, sent the sister a video. Now, this video was circulating throughout the community in Jamaica and over here. I received it, but something was disturbing about it. I didn't even open it up. Well, anyway, Denise now, sister sent it to her. She did not get the opportunity. She did not look at it, but she was found guilty. All right, here it goes. The case started in February 2018 after Williams was sent a WhatsApp message by her sister. The sister got it from the boyfriend, containing a video of a young girl being attacked. The sister was outraged and wanted the culprit hunted down by police. This was the same thing that was said in Jamaica, but in Jamaica they're saying that if anybody that views it and distribute it will be charged with child pornography and child distribution, pornography of children, right? But they said they understand they wanted people to see who the culprit was. It was very disgusting, right? Williams never played the video. Forensics stated Williams never played the video, and she maintained she never knew it was on her phone and thus in her possession. Right? But the prosecution said Williams failed to report it because the fear doing so would get her sister into trouble. The mere thing is, if she never saw the video and she did not look at it, how are you going to charge her for it? Right? So let's put it this way. Let's say somebody sent you anthrax, right? Police is following anthrax. Police is following a bomb. And they come to your house, really not this package, right? And they say, oh, anthrax, I'm going to charge you for anthrax, or I'm going to charge you for a bomb. Now, that don't make a lick of sense to me, period, right? So, she should never be charged. And look at it the conspiratorial theory, from a conspiratorial theory way. Let's say us as African Caribbean, right? HG, with it, HGC, the GCHQ, right? Gets an algorithm and notice that black people is always watching a particular video, right? So now they set the algorithm to send out this child pornography. None of us open it because we don't know what it is, so we don't even have the time. And next minute you hear police come knocking at your door. What? Arresting you, looking to charge you for child. Well, what would it be? I'm saying that's a conspiratorial theory. That's the reason why none of this makes no sense. Because at the end of the day, right, I'm gonna play something for you, right? But before I play that, I want you to understand this. David Cameron. David Cameron, Pig's Head and a Secret Society at Oxford University explained. Now, what it was, David Cameron, I think it was initiation, right? And he had to, in part of joining or being initiated into this group, he had to put a private part. One specific allegation is that, in the words of the Daily Mail, Cameron took part in an initiation ceremony in which he put a private part of his anatomy into a dead pig's mouth. Now, how come he did not sue or press criminal charges for the person that wrote that book? Because I saw the video and the dude was saying, sue me, bring criminal charges against me. But David Cameron couldn't do that, because he's the prime minister, so he couldn't turn around and say to the masses of people or going to the court and say, well, you know what, I'm going through emotional duress, I can't sleep, I can't drink, I can't eat, I can't do nothing. Then you're not fit to be president or prime minister of the UK, all right? So he couldn't say nothing, because the information was true. Also, according to the story, also his wife told the children, if you go to school and the children say oink, oink, right? Pay them no mind. Alright? So that was what you see as far as David Cameron is concerned, this information, because technically he was supposed to, alright? But they did not do that because, as I said, it's going to make him look like, you know what, you ain't fit to run the country. Right? Now remember, at the end of the day, and I'm trying to make this short, at the end of the day, right, it's all about how do we try to understand or understand the law. That's why I'm asking you to leave your comments, right, so that we can try to pursue it, because I think you need 100,000 signatures to send to legislators to say, amend this law. Have something that you and I can do research. Take this as an example, right? Here goes this woman here, right? Elizabeth Kenny was convicted under the UK Communication Act 2003 for sending a grossly offensive message with a hate crime uplift due to homophobic language using the word faggot. Right? Now, the backstory behind this female is that she went out to a party with a group of individual friends. She was assaulted. She decided now she's in the hospital and she's so peed up that she sends out a text to this individual, a male, and he takes that text, or the police, but I get to understand or understand that he took the text to the police. They charged her for homophobic, and violation of the Malicious Communication Act. All right. Now she was assaulted. She's in the hospital. She's peed off. She's in a different state of mind. All right. But that's what happened. Now here's this. Now I want you to listen to this. Right. Where is it? I want you to listen to this. This is Pierce Morgan. Listen to me carefully before we go any further. Under the Malicious Communication Act in the UK, right? Germany is 200 cases for the year. In America, it's almost 200 for the year. How much cases do you feel is brought up under criminal charges in the UK under the Malicious Communication Act? I'll wait. Take an educated guess. I'm yours. I'm all ears. Take an educated guess. Well, you don't want to work with me? I'll make you work with me. Take a listen to this. This is Pierce Morgan.
The bigger issue, it seems to me, here with the UK is that the Times newspaper recently revealed that police officers are making 12,000 arrests a year under Section 127.
Did you hear what he just said? 12,000 arrests per year. That's telling you there's something wrong. The average citizen out there sent out any kind of text like this female, she got paid. In the United States, you'd have to say kill, shoot, or harm. I'm going to shoot a Chinese. I'm going to rape a Chinese. I'm going to kill. Then yes, whatever slur goes with that, then yes. But you just turn around and saying, oh, you stole my money and I want my money back. And that person can take that information straight away in the UK and you get charged. Continue.
Of the Communications Act and Section 1 of the Malicious Communications Act. In other words, similar instances to this. That's 30 arrests a day over offensive posts on social media and other platforms. Thousands of people being detained and questioned for sending messages that, quote, cause annoyance, inconvenience, or anxiety to others via the internet, telephone, or mail. There's been a 58% increase in these arrests since before the pandemic. This seems completely nuts to me. Joe Rogan said they've already arrested 12,000 people for social media posts. We got a clip of him talking about this.
They've already arrested 12,000 people for social media posts.
That's insane.
Above and beyond every other country, way above Russia. Russia was like 400 last year. The UK is 12,000. Any criticism of immigration, any criticism of grooming gangs and people being raped, any talk about how horrible this is, they come visit you. It's like someone's trying to destroy England.
Okay, so you got it. 12,000. That means that the judicial system is geared against the poor people or the average person as a class system. All right? Because look at Andrew. Look at what he went through. And no criminal charges. But yet still, if somebody steals your money, takes your money, and you've been trying to get in contact with them, and they won't give you your money, and you go on social media and say, man, you stole my money, give me my money. That person now can go into the police station and press criminal charges against you, and you will be found guilty. Because remember, this whole magistrate thing that David Lammy wants to change is giving more powers to the magistrate and overburdening the magistrates, and they don't know nothing about law, so that means you're going to get more prison time. So what I'm asking you all to do is leave the comments on if you get arrested and you're going through the system and you want to fight your case. I've given you the example of the Miranda. I've given you an example of Wade. I'm asking you to help me. Where do you go? So that means that I can help you. Or let me rephrase it. You can help me. I can help you so that you can help your children. At least they've got some kind of information, because we can't be walking through the woods blind. That don't make a lick of sense to you and I. As I said, I've not taken this, doing this to address any issues that was put in as far as Palestinian action. That ain't got nothing to do with me, period. Maybe another time in the future, but not now, period. Anyway, this is the original OG from Omega FM Radio. .co.uk. As I said, we give you a little bit of this and a little bit of that. Please subscribe. All I wanted you to know is that do this. And that's the way I see it. I'm telling it from where I'm sitting from, my point of view. So anyway, listen, as I said, think before you think, before you think. If you have the information, I don't care how small it is or how big it is, please, please, please send it to me. All right, so that I can do the research and I can bring it back to you and you can turn on and say, well, yes, no, whatever, whatever. Anyway, on that note, y'all have a pleasant one. Take care. I'm through the door. Peace one. I'm out.